Okay, welcome to unit/week 2, professional responsibility video lecture. And basically, again, this is to supplement your reading and also to go through these things outside of the classroom, so when we're in the classroom, we can apply this knowledge. We can apply these rules to the different questions asked in the textbook, as well as the multiple choice questions, and also some other questions that I may or may not bring into class from time to time. Also in class, we will be going through, as usual, the cases that are assigned to you in your reading. Those include the cases that are in your textbook, as well as cases that will supplement your textbook from California. So let's start. All right, so one of the rules that the textbook went after or is going through in Chapter 2 has to do with the unauthorized practice of law. This is the ABA Rule 5.5, and it has to do with multi-jurisdictional practice of law. Well, we saw that in a case, a pro hoc vice case, and we'll talk about that a little bit about in this rule, and we'll also go through that case in class. But some of this rule is very straightforward, and some of it is not, and you have to understand when you're in a jurisdiction that is foreign to where you're licensed, what those rules are, and when and how you're able to practice in those foreign jurisdictions. So it says, a lawyer shall not practice law in a jurisdiction in violation of the regulation of the legal profession in that jurisdiction, or assist another in doing so. A lawyer who is not admitted to practice law in this jurisdiction shall not, except as authorized by these rules or other law, establish an office or other systematic and continuous presence in the jurisdiction for the practice of law. A good example of this is where you have multi-office law firms, national law firms. You have lawyers, say, who are in New Jersey, who are licensed in New Jersey, but there's another office that's in California, and they're not licensed there, so they, of course, can't practice there. And you often hear in the United States commercials where an attorney will be talking about the services that his firm performs and provides, and it is a national firm, and the attorney will have to say, I personally am not licensed outside of these other jurisdictions, but we do have lawyers that are. So that's one of the ways to get around this. There's also reporting requirements on that letterhead of national firms stating which attorneys who are partners are licensed to practice law and where. However, but there are rules and laws that establish multi-jurisdictional practices. An attorney should also not hold out to the public or otherwise represent that the lawyer is admitted to practice law in this jurisdiction. Again, I'll go back to the caveat when you hear some commercials in the United States, the attorney who is voicing over the commercial will say, I'm not, or I'm only licensed in certain jurisdictions. So therefore, they get away from holding out to the public that they are licensed in the jurisdiction. Here is a lawyer admitted in another United States jurisdiction and not disbarred or suspended from practice in any jurisdiction may provide legal services on a temporary basis in this jurisdiction that, so may provide, it's not shall, it's may, so it's discretionary, are undertaken in association with a lawyer who is admitted to practice in this jurisdiction and who actively participates in the matter. When I did plaintiffs, when I was with a plaintiff's firm, I often, well, not often, there was a few times that I had to go outside of my jurisdiction and participate in a case, and I was always in association with a lawyer from that jurisdiction. Okay. That are in or reasonably related to a pending or potential proceeding for a tribunal in this or another jurisdiction, if the lawyer or a person the lawyer is assisting is authorized by law or order to appear in such proceeding or reasonably expects to be so authorized. I highlighted in italicized order, that's the pro hoc vice term, basically. That the court will provide an order that you can appear before the court on a temporary basis for a single issue or a single client. And I was pro hoc viced into a couple of jurisdictions, including California and Tennessee. I was also pro hoc viced in Arizona, but I never appeared there. So those were 3 places outside of where I was licensed to practice law, which is Pennsylvania, New Jersey, and Washington, D.C., that I was allowed to appear by order of the court. This was done through order of the court, and there's a case that goes through that process in California. And in fact, that's what I did in I was pro hoc viced into California. Okay, number 3, are in or reasonably related to a pending or potential arbitration, mediation, or other alternative resolution proceeding in this or another jurisdiction if the services arise out of or are reasonably related to the lawyer's practice in a jurisdiction in which the lawyer is admitted to practice and are not services for which the forum requires pro hoc vicee admission. So this is ADR stuff. So they give you a little leeway concerning ADR. If you are going to go to some type of alternative dispute resolution concerning a case from your jurisdiction, they can hear that in another jurisdiction, and you will not be practicing law unauthorized. And you saw 1, 2, 3, 4 is or, not and, it's or, are not within paragraph C2 or C3 and arise out of or are reasonably related to the lawyer's practice in a jurisdiction in which the lawyer is admitted to practice. Then we go to D, a lawyer admitted into another U.S. jurisdiction or in a foreign jurisdiction, that would mean outside of the United States, and not disbarred or suspended from practice in any jurisdiction or equivalent thereof, or a person otherwise lawfully practicing as an in-house counsel under the laws of foreign jurisdiction may provide legal services through an office or other systematic and continuous presence in this jurisdiction. So this is about in-house counsel that are provided to lawyers' employer or its affiliates, are not services for which the forum requires pro hoc vicee admission, and when performed by a foreign lawyer and requires advice on the law of this or another U.S. jurisdiction or of the United States. Such advice shall be based upon the advice of a lawyer who is duly licensed and authorized by the jurisdiction to provide such advice. So if you're in-house, you need advice from another jurisdiction, you can get it from another lawyer and take that advice. Or are services that the lawyer is authorized by federal or other law or rule to provide in this jurisdiction, such as immigration law is one of those authorized by federal law. If you're not licensed in a certain jurisdiction, you may still practice immigration law in most jurisdictions. For purposes of paragraph D, the foreign lawyer must be a member in good standing of a recognized legal profession in a foreign jurisdiction. So if you're a Korean attorney and licensed in Korea, the members of which are admitted to practice as lawyers or counsels at law or the equivalent, that's the Korean bar, for example, and subject to effective regulation and discipline by a duly constituted professional body or public authority, which I assume is the case in Korea, or the person otherwise lawfully practicing as in-house counsel under the laws of a foreign jurisdiction must be authorized to practice under this rule by, in the exercise of its discretion, the highest court of the jurisdiction. So a Supreme Court, a state Supreme Court can provide you, it has the authority to authorize you to practice. Okay, so the unauthorized practice of law. So basically, the bottom line is you have to know the rules in the jurisdiction to which you want to practice concerning if you're going to be practicing outside a jurisdiction in which you are licensed. Okay? You can't just show up because you're licensed in one jurisdiction and start practicing in another jurisdiction. The most prominent way of getting authority to practice in another jurisdiction is the pro hoc vicee order of a court. And here we have California's rule of court concerning counsel pro hoc vicee. And pro hoc vicee is basically translated for this occasion. So it's a one-time thing. So in California, the eligibility to practice pro hoc vicee, and like I said I was pro hoc vicee into California in the spring of 2008 for a case when I was with the plaintiff's firm. And let's see if I met the requirements, because I wasn't the one who put through the application. Someone did it for me. All I had to do was sign it. I worked for a big firm, so those were one of the perks of working for a big firm. You had other people to do things for you. So the eligibility is a person who is not a member of the State Bar of California, which I wasn't and I am not, but who is a member in good standing of and eligible to practice before the bar of any United States court or the highest court in any state, which I was, New Jersey, Pennsylvania, and Washington, D.C. Territory or insular possession, I was state and territory because Washington is a territory, Washington, D.C. And who has been retained to appear in a particular cause pending in the court of this state. I was retained by the client, or at least our firm was retained by the client, may in the discretion of such court be permitted upon written application to appear as counsel pro hoc vice, provided that an active member of the State Bar of California is associated as an attorney of record. And the lead attorney on the case was indeed a woman who was licensed in California. Her name was Kim Valentine. She had her own firm, and we were co-counsel, she being the lead. So she was who provided the active membership, and therefore I met, and also my colleague, or my boss actually, who was not licensed in California, met the eligibility requirements. Okay, here's F. Counsel pro hoc vice, subject to jurisdiction of courts and state bar. So this goes specifically to one of the cases that was assigned in your reading. It says a person permitted to appear as counsel pro hoc vice under this rule is subject to the jurisdiction of the courts of this state with respect to the law of this state governing the conduct of attorneys to the same extent as a member of the State Bar of California. The counsel pro hoc vice must familiarize himself or herself and comply with the standards of professional conduct required of members of the State Bar of California, and will be subject to the disciplinary jurisdiction of the State Bar with respect to any of his or her acts occurring in the course of such appearance. Article 5, Chapter 4, Division 3 of the Business and Professions Code and the Rules of Procedure of the State Bar govern in any investigation or proceeding conducted by the State Bar under this rule. Basically, what California is telling you, if you want to come in here and practice and we pro hoc vice you are subject to all the rules and requirements of the attorney licensed in California, and thus you would be subject to the rules and regulations of professional conduct, as well as any type of discipline concerning those rules that the licensed members of the California State Bar are subject to. All right? Okay, so now we go on and we move into maintaining the integrity of the profession concerning the ABA rules. And Rule 8.1, bar admission and disciplinary matters. This is something that all of you are going to be going through very soon. So pay close attention to this rule, and also the couple of cases in the rule that apply this, a couple of cases in your reading that apply this rule. An applicant for admission to the bar or a lawyer in connection with a bar admission application or in connection with a disciplinary matter shall not. So this has to do with applicants, and this also affects a lawyer after they've been admitted. Shall not knowingly make a false statement of material fact in their bar application, or fail to disclose a fact necessary to correct a misapprehension known by the person to have arisen in the matter, or knowingly fail to respond to a lawful demand for information from an admissions or disciplinary authority, except that this rule does not require disclosure of information otherwise protected by Rule 1.6. Okay, so that last one only applies, of course, to the attorney-client privilege. So that's someone, that's an attorney that after they were admitted, a bar applicant does not have attorney-client privilege, does not have confidentiality privileges or anything like that. Okay, let's go on. So comment 1. As I stated earlier, it says the duty imposed by this rule extends to persons seeking admission to the bar as well as to lawyers. Hence, if a person makes a material false statement in connection with an application for admission, it may be the basis for subsequent disciplinary action if the person is admitted, and may, in any event, may be relevant in a subsequent admission application. So therefore, if you pull one over on the bar examiners, and you do not, as they say, if you make a false statement of material fact, or if you fail to disclose certain information or respond to a request for lawful information, then you may get licensed, but it could come back to haunt you, and they may find that you have committed fraud in filing your application for the bar, and then pull the license from you, suspend you, or in a subsequent, if you want to get admitted to a subsequent bar, they may find some things from a previous bar application that don't jive with the current bar application, and that will bring up red flags to them. So therefore, they can reject you, and then they can also notify the bar, the bar board where you are licensed, and bring you up on charges, because as you'll see, that is required to report such misdeeds to the bar disciplinary authorities. Okay, here your reading material said read 8.1 through 8.5, and they really didn't go through all of them, but just to keep in check with the reading, this is judicial and legal officials, again, maintaining the integrity of the profession, Rule 8.2. The lawyer shall not make a statement that the lawyer knows to be false or with reckless disregard as to its truth or falsity concerning the qualifications or integrity of a judge, adjudicatory officer, or public legal officer, or a candidate for election or appointment to judicial or legal office. Basically, this is saying, hey, you got to keep things in the courtroom. You can't go out into the press and start bad-mouthing judges. Okay. A public legal officer is an officer such as an attorney general. You don't want to badmouth those as well because of the integrity of the profession. So you could be brought up on charges for doing this. And when it says, you shall not make a statement that the lawyer knows to be false or with reckless disregard as to its truth or falsity, you really just want to remain silent. Keep any problems you have with the judge in the courtroom or in the chambers of the judge. It says a lawyer who is a candidate for judicial office shall comply with the applicable provisions of the Code of Judicial Conduct. Okay, we'll be getting into those later on in the semester. Here we are, now moving on to Rule 8.3, reporting professional misconduct. So, you're required to report professional misconduct, but not all instances of professional misconduct. So, Rule 8.3, again, this is maintaining the integrity of the profession. 8.3, reporting professional misconduct. A lawyer who knows that another lawyer has committed a violation of the rules of professional conduct that raises a substantial question as to that lawyer's honesty, trustworthiness, or fitness as a lawyer in other respects shall inform the appropriate professional authority. So whoever the appropriate professional authority is in the jurisdiction and where that attorney is practicing, if there's a substantial question to that lawyer's ability or fitness as a lawyer is raised, you must report it. You should report it. A lawyer knows that a judge has committed a violation of applicable rules of judicial conduct that raises a substantial question as to the judge's fitness for office shall inform the appropriate authority. So you have a responsibility to report judges as well. This rule does not require disclosure of information otherwise protected by Rule 1.6 or information gained by a lawyer or judge while participating in an approved lawyer's assistance program. So if another lawyer comes to you and says, I think I've screwed up, I need some help, I need some, I may need you to, I may need to become your client, I may need you to represent me. And then you start telling that other attorney about what you did, well, that becomes confidential information. It's privilege, attorney-client privilege, and as part of any follow-up research or investigation that the attorney does, it becomes confidential. So if you find out about professional misconduct in your relationship with another attorney, as that attorney is a prospective client or client, then therefore you don't have to. You are not required. And also there are certain bar associations, maybe all of them, have set up certain assistance programs, that's what they call them, hotlines or whatever, where a lawyer needs help. Also, you're not required to make disclosures concerning information that you find concerning a lawyer's misconduct in those instances either. Now, comment 3. So let's flush out what is a substantial, a substantial question as to the lawyer's fitness. What raises a question? What is a violation? It says this rule limits the reporting obligation to these offenses that a self-regulating profession must vigorously endeavor to prevent. A measure of judgment is therefore required in complying with the provision of this rule. The term substantial refers to the seriousness of the possible offense and not the quantum of evidence of which the lawyer is aware. So if you know of something, but you don't have a whole lot of evidence beyond it, this comment is basically saying if it's really a serious offense, regardless of the evidence, you should probably report it. Okay. However, a lawyer is not required to report every violation of the rules of professional conduct or otherwise. It's a self-regulating profession, and there is some discretion. I'm sure you can be brought up on charges for not reporting things, but you do not have to report everything. Comment 4. The duty to report professional misconduct does not apply to a lawyer retained to represent a lawyer whose professional conduct is in question. Such a situation is governed by rules applicable to client-lawyer relationship. We spoke about that just previously on the other slide. If you are advocating or representing another attorney who's been brought up on charges or sought your advice because he's afraid he might be brought up on charges, or he sought your advice because he doesn't know whether he violated substantially or even not substantially certain rules of professional ethics, you can't disclose it, or you shouldn't disclose it. Okay, what is professional misconduct? Well, this rule tries to make it clear, although I don't think it does. I think professional misconduct is really dependent upon the zeitgeist of the time, what people think. It's very relative. Moral relativism is a big, big deal, I think, in determining what misconduct is concerning these rules. And you'll even see certain moral relativism enumerated and commemorated in the rules themselves. So let's go through 8.4, misconduct. What is it? Again, this is about maintaining the integrity of the profession. It is professional misconduct for a lawyer to violate or attempt to violate the rules of professional conduct, knowingly assist or induce another to do so, or do so through acts of another. So you can't attempt to violate the rules of professional conduct. Is that a substantial? Does that raise a substantial question if you violate any rule of professional conduct? Who knows? Commit a criminal act that reflects adversely on the lawyer's honesty, trustworthiness, or fitness as a lawyer in other respects. So oftentimes The fitness to be an attorney is one of honesty and trustworthiness. Okay? So they look at crimes, especially those crimes that show a lack of trustworthiness and honesty. Theft, fraud, deceit, things like that, when determining whether that's a professional misconduct. Engage in conduct involving dishonesty, fraud, deceit, or misrepresentation. So it doesn't have to be a criminal act. It can be just a certain type of conduct. What type of conduct may that be? Well, you could, breach a contract. All right? That could be a dishonesty. Engage in conduct that is prejudicial to the administration of justice. So this goes to things that you're doing in your representation of a client. Are you being truthful and honest to the judiciary, to the other side? Are you squelching evidence? Are you throwing up roadblocks? Anything that gets into is a roadblock to the administration of justice could be misconduct. State or imply an ability to influence improperly a government agency or official, or to achieve results by means that violate the rules of professional conduct or other law. So you can't go to someone and say, hey, I know the governor, I can do this, and things like that. Okay? So, F, knowingly assist a judge or judicial officer in conduct that is a violation of applicable rules of judicial conduct or other law. So that could be misconduct. So here's a new one. This is brand new. Well, I don't know if it's brand new, but sexual orientation and gender identity have been added to this recently. Probably gender identity the most recently. And it says that it's misconduct if a lawyer or a member engages in conduct that the lawyer knows or reasonably should know is harassment or discrimination on the basis of race, sex, religion, national origin, ethnicity, disability, age, sexual orientation, gender identity, marital status, or socioeconomic status in conduct related to the practice of law. Okay, so you can't discriminate. Now, not all states have adopted this rule to include the gender identity or sexual orientation. I know a lot of states have adopted the rule concerning sexual orientation. Gender identity is the new zeitgeist of the rainbow jihad. This is problematic, though, when it comes to what is discrimination. Okay? When it comes to these things. So, for example, if someone comes into your office and they're white, and you say, I'm sorry, I won't represent white people, well, that's discrimination related to the practice of law concerning race. If someone would say the same thing about, I don't represent men, I don't represent Christians, I don't represent Americans, of course that would be stupid if you're an American attorney. You say, well, I don't represent the Irish, people of Irish ethnicity, or people who come from Ireland. Or, hey, if you wear glasses, I won't represent you. If you're 25, I won't represent you. Well, that's pretty straightforward. Okay, so you have a bias or discrimination against those things. But when it comes to sexual orientation, what if someone walks into your office and says, I want a divorce, and it's a man. He says, I want a divorce from my husband, another man. What if you say, well, I don't do that. I don't do gay divorces. Is that harassment? Is that discrimination on the basis of sexual orientation? What about gender identity? Someone comes in and says, you know, well, let's move on. So, but however, it says this paragraph does not limit the ability of a lawyer to accept, decline, or withdraw from a representation in accordance with Rule 116. Remember, Rule 116 has in it if you find what your client wants to do as being repugnant. Okay? So this paragraph does not preclude legitimate advice or advocacy consistent with these rules. I don't really know what that means. But if someone walks in and they're gay and they want you to do their divorce from their other gay spouse, you're like, I don't do that. I do normal divorces. Okay? Can you be required or can you be sanctioned, disciplined under these rules for that? What if you don't believe that in gay marriage? What if you believe only in the biblical concept of marriage of one man and one woman? Are you discriminating against someone based on their sexual orientation? Well, I would guess that the answer would be in places like New York, California, Oregon, the state of Washington, New Jersey, all the other leftist type states. The answer would be yes. And even those states that are considered moderate, usually the bar, the board or the bar association in those states are very far left, and I think basically that you would be considered discriminating. So let's look at some of the comments concerning subsection G of Rule 8.4. First, this is a general comment about misconduct, and it's kind of funny. So let's go through it. Kind of funny as in not funny haha, but funny as in sad. Comment 2 says many kinds of illegal conduct reflect adversely on fitness to practice law, such as offenses involving fraud and the offense of willful failure to file an income tax return. So fraud, that's dishonesty, non-trustworthiness, failure to file an tax reform. I guess you can say that's not being honest. You're not reporting your income to the government. It says, however, some kinds of offenses carry no such implication. Traditionally, the distinction was drawn in terms of offenses involving moral turpitude. That concept, meaning moral turpitude, can be construed to include offenses concerning some matters of personal morality, such as adultery, and comparable offenses that have no specific connection to the fitness for the practice of law. Okay, so adultery, they're saying, though it may be involve an offense of moral turpitude, lying and cheating on your spouse and breaking the trust of your spouse of one of the most sacred obligations you've ever made, well, that has no specific connection to fitness for the practice of law, because adultery is not being dishonest, deceitful, or untrustworthy, right? Okay, let's go on. Although a lawyer is personally answerable to the entire criminal law, a lawyer should be professionally answerable only for offenses that indicate lack of those characteristics relevant to law practice. So when it comes to criminal law, it says offenses involving violence, dishonesty, breach of trust, or serious interference with the administration of justice are in that category. I don't quite understand, although it's not that I disagree, but I don't understand why violence is applicable, because does that really have anything to do with you being honest and trustworthy? I don't think so. I think adultery, even though adultery is not really considered a crime anywhere, or it's not prosecuted as a crime, even if it is considered a crime in certain states, is much more an indicator that you are not trustworthy than violence is. And again, I'm saying I don't disagree that violence should could be misconduct concerning a lawyer, but it really doesn't go to dishonesty, breach of trust, or serious interference with the administration of justice unless you're beating up another opponent's witnesses. Okay, let's go on. A pattern of repeated offenses, even ones of minor significance when considered separately, can indicate indifference to the legal obligation. So if you have a quantity of repeated offenses, even if they're minor, this can be considered misconduct that substantially affects your fitness to practice law. Note, Now, in that comment, it talks about moral turpitude. Now, moral turpitude is a legal concept in the United States that refers to an act or behavior that gravely violates the sentiment or accepted standard of the community. So maybe you could read comment 2 to say that adultery is an act or behavior that gravely violates the sentiment or accepted standard of the community. But it says really it has no specific connection to the fitness for the practice of law because, hey, adulterers aren't dishonest, untrustworthy, even though adulterers are the very epitome of dishonest and untrustworthiness. But again, this is the zeitgeist in which we live. Moral turpitude is really moral relativism when it comes to the application of what is misconduct in the legal profession in many instances. Now let's get back to paragraph G, which concerns the rainbow jihads concerning sexual orientation and also so-called gender identity. Discrimination, comment 3, discrimination and harassment by lawyers in violation of paragraph G undermine confidence in the legal profession and the legal system. Right. So telling someone that you're not going to advocate or represent them because they're white, that undermines the system. Or because they're a man, that undermines the system. Or because they're from Ireland, that undermines the system. What if you went in and they said we don't represent Koreans, right? Such discrimination includes, now look at this, because this is the way things are going. It says such discrimination includes harmful verbal or physical conduct that manifests bias or prejudice towards others. Now, verbal, it says, it should be read, such discrimination includes harmful verbal conduct. Speech is not conduct, though that is what the left is trying to transform speech into. So if speech loses its expressive nature, it therefore is not or no longer protected under the First Amendment. So as much as possible, the left is trying to create speech into conduct. And these comments are part of what they're trying to do. Okay, but let's look at that. Verbal conduct that manifests bias. What do you mean bias? If you are against gay marriage and you have said so, and if you have conducted yourself, whereas I did in 2008, I donated to the Proposition 8 pro-marriage California referendum, where Californians amended their constitution to state that marriage is only between one man and one woman, and that referendum passed overwhelmingly. I gave money to the cause behind that referendum. That's conduct. Have I now manifested a bias against gay people? I think people who write these rules would say yes, and that I have my conduct is misconduct according to these rules. Harassment includes sexual harassment and derogatory or demeaning verbal or physical conduct. Okay, remember, verbal conduct. It's no longer expression. They're trying to change it into conduct. So what is derogatory or demeaning verbal conduct? If I state I am only for biblical marriage, as an attorney, if I would represent a state to try to overturn the Obergefell decision, am I showing derogatory or demeaning verbal conduct towards homosexuals? Okay, let's keep going. Sexual harassment includes unwelcome sexual advances, requests for sexual favors, and other unwelcome verbal or physical conduct of a sexual nature. This is becoming very contentious in the workplace in the United States, when what really is sexual harassment? Is it someone's perception? Is it based upon intent? It goes to all these safe spaces and the victimization that's going on in the United States. So basically what's happening is men really don't want to talk to women in the workplace anymore because of the so-called verbal conduct, and that goes with men as well. So let's go on. Again, comment 4 then. Comment 4 is probably the worst comment in the new addendum to these rules concerning sexual orientation and so-called gender identity. It says conduct related to the practice of law. So remember, this is supposed to only apply when it is conduct or verbal conduct related to the practice of law, this rule. And it says it includes representing clients, interacting with witnesses, co-workers, court personnel, lawyers, and others while engaged in the practice of law, operating or managing a law firm or law service, and participating in bar association, business, or social activities in connection with the practice of law. What the heck does that mean? Okay, so if I belong to the Christian Legal Society and I go to a dinner, which is it's a local, it's not a bar association, but it is a legal association, the Christian Legal Association, and they have a dinner and a speaker, and it's about how we need to bring back the biblical concept and definition of marriage to our laws. Have I manifested a bias and prejudice towards others? I think that the people in California and the people who write these rules and make these comments would say I do, and that I have performed a misconduct. Okay, let's go on. Lawyers may engage in conduct undertaken to promote diversity and inclusion without violating this rule. By example, implementing initiatives aimed at recruiting, hiring, retaining, and advancing diverse employees, or sponsoring diverse law student organizations. So this comment, this part of the comment says, look, what we're really saying is you can have a bias in favor of certain groups. And we'll tell you which groups you can have a bias in favor of. And you can discriminate against other groups. And we'll tell you which groups you can discriminate against. That's what these cheery words are. Lawyers may engage in conduct undertaken to promote diversity. What does diversity mean? Well, they'll tell you what it means. And what type of conduct? Well, the conduct will be discrimination and bias towards certain groups. And guys, this is what the left does. They just turn everybody into identity groups and pit everybody against each other to where society can no longer stand. Okay? So basically, they may engage in conduct undertaken to promote diversity. Well, what does that mean? And what type of conduct is that? Well, they'll tell you who it is. Okay? Suppose I want to promote diversity amongst Irish, and there's not enough Irish people in my law firm. Am I allowed to do that? Well, the Irish people are considered white, so no. They would say no. All right? So you guys don't have to worry about this much when you're working in a non-diverse country such as Korea. The United States, this has really become a pain, and it's really become a calling card of the left to create hostility among certain identity groups and to pit identity groups against each other. It's basic Marxism, it's basic Satanism. Okay, now we're on to some California laws. Now, Chapter 3, professional relationship with clients, avoiding interest adverse to a client. And this goes to the cases that the supplemental case concerning Ames v. State Bar. And there might be another case I'm reading as well. But that is the case that will be forwarding to you. So for California, the professional relationship with clients, avoiding interest adverse to a client, it says a member shall not enter into a business transaction with a client or knowingly acquire an ownership, possessory security, or other pecuniary interest adverse to a client unless each of the following requirements has been satisfied. So in the case that you've been given concerning this, Ames v. the State Bar, it's a case from 1973 and the rules were different. Basically, that rule was California Professional Rule Responsibility Rule 4, which stated that a member of the State Bar shall not require an interest adverse to his client. And remember, when you read in that case, it says this rule is absolute. But as you can see now, the change and the update to that rule, which is now California Rule 3-300, there are exceptions to it, and these exceptions are enumerated in the rule itself. It says the transaction or acquisition, so that means business transaction or an acquisition of property, and its terms are fair and reasonable to the client and are fully disclosed and transmitted in writing to the client and in a manner in which reasonably have been understood by the client, and the client is advised in writing that the client may seek a second opinion, and the client thereafter consents in writing to the terms of the transaction or the terms of the acquisition. So whereas in the Ames v. the State Board case, Rule 4, it says, was absolute in its terms with no exceptions, California Rule 300, which is an update to Rule 4, provides exceptions or requirements that will meet an exception to the absoluteness to the rule. Okay, so like I said, note the rule has changed since Ames and is no longer absolute. So look at this rule and see if the requirements have been met in the Ames v. the State Bar case. And if this rule were enforced back in, I guess it's the late 60s, early 70s, whether the attorneys, the petitioners in that case, would have been in violation of this rule. Here's some comments. So Rule 330 or 3-300 is not intended to apply to the agreement by which a member is retained by the client. So you can enter into a transaction, a business transaction with the attorney, in that you establish the business relationship of the attorney-client relationship. However, it does say, got to worry about fees though, and that is governed by Rule 4-200. We'll get into that later in the class. Comment 2, 3-300 is not intended to apply where the member and client each make an investment on terms offered to the general public or a significant portion thereof. So suppose they buy stock in the same company, or they enter a partnership that is outside of law that other people were advertised to enter and things like that. That does not apply to those types of transactions. Comment 3 is intended to apply where the member wishes to obtain an interest in the client's property in order to secure the amount of the member's past due or future fees. Okay. Now let's go to 4-300, financial relationship with clients. Again, this had to do with the Ames case as well. It says purchasing property at foreclosure or sale subject to judicial review. It says a member shall not directly or indirectly purchase property at a probate, because that's a will, foreclosure, receivers, trustees, or judicial sale in an action or proceeding in which such member or any lawyer affiliated by reason of personal, business, or professional relationship with that member or with that member's law firm is acting as a lawyer for a party or as executor, receiver, trustee, administrator, guardian, or conservator. So if the lawyer is involved in the sale or related to someone who's involved in the sale, who's acting as an attorney for one of the parties or the executors, receiver, trustee, administrators, they are not allowed to purchase property. They are not allowed to purchase the property. And then B, a member shall not represent the seller at a probate, foreclosure, receiver, trustee, or judicial sale in an action or proceeding in which the purchaser is a spouse or relative of the member or another firm in the member's firm or is an employee of the member. So basically, concerning this rule, and this has to do with Rule 8 back in the case. And Rule 8 in the Ames v. the State Bar case is, a member of the State Bar shall not directly or indirectly purchase property at a probate, foreclosure, or judicial sale in an action or proceeding in which such member appears as an attorney for a party. This is still an absolute rule. Okay, so if you see an attorney doing such a thing, but has not entered into an agreement with the client, they can't do this. Okay, and it's because it's a conflict of interest inherent in the situation, and that is, if you are representing a client who's selling a property, you want them to get the best price for the property. But if you're going to be purchasing that property, you yourself want to get the best price, and it wants to be a cheaper price. So there's the inherent conflict. Okay, this is the final slide, and this is just an overview of a general disciplinary process, and that you saw in reading some of the cases that were assigned to you for unit or week 2. So the disciplinary process usually starts with a complaint, and it's usually made to the state bar or a disciplinary authority within the state bar. And that complaint is made by anyone with knowledge of the misconduct. Now, of course, if you're an attorney and you have knowledge, you are required, if it is a substantial, if it shows a substantial impact on the fitness of the attorney, or if it's a lot of different things, you are required to report it. The complaint can be dismissed, or they can ask the attorney who the complaint has been made against for a response. If meritorious, they can commence an investigation. So when a complaint is filed with the disciplinary body of the state bar, they can look at it and term, just from the complaint itself, that it's frivolous and dismiss it. Or they can say there may be something to this complaint. They can ask for a response from the attorney against whom the complaint was made. And then maybe they can dismiss it then, or they can look and say, hey, this is a meritorious complaint, and therefore we have to commence an investigation. Okay, so then there would be a hearing, and the burden of proof is on the state, usually the burden of proof on the state bar, and usually that burden is higher than preponderance of the evidence. Could be clear and convincing, but it's certainly not beyond a shadow of a doubt. During the hearing, there's due process is required, and rules of evidence by state vary concerning these procedural hearings, disciplinary hearings. Appeal. So if it's a bad, either side can appeal an adverse decision, and that would be appealed to the highest state court usually. You saw that in the Ames v. State Bar case. It was an appeal to the Supreme Court. Now, of course, there were a couple other steps and levels in the California State Bar, so the disciplinary process is not the same for every state or every jurisdiction, but this is, like I said, this is a general overview of what happens. Sanctions. So if they find out that the complaint is meritorious and they have met their burden of proof, there are a few types of sanctions that they can implement. One is a private reprimand or censure, and that is basically a little mean letter into the file of the attorney saying don't do this again. A public reprimand, and private, of course, means that it's only between the attorney and the board. A public reprimand, maybe they want to send a message to other attorneys, and maybe the misconduct was a little bit worse than what a private reprimand, or maybe it was the second time or third time, and they want members of the bar to know that this person has done this. Or there can be a suspension or a disbarment. A suspension is where the person is relieved of their ability to practice law for a stated period of time and then can regain that ability. The disbarment is where they lose their license permanently. And I guess there's probably procedures somewhere concerning rehabilitation that they can seek reinstatement, and that again is based on the different jurisdictions and the rules in those jurisdictions. Okay, so thank you for listening, thank you for watching, and we will see you in class. This was a long one. I'm sorry about that. God bless.